We will go on the record in the matter 25 CF 36, State of Wisconsin versus Christine Stewart. This date appears through District Attorney Kevin Schmidt in person. We have Ms. Stewart appearing in person with counsel Emma Campion. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Can you please recite it for the record, Ms. Campion?
Yes, Your Honor. Ms. Stewart will plead to count 2. Counts 1 and 3 will be dismissed and read in. The parties jointly recommend a withheld sentence and a probationary period of 18 months. I believe the conditions recommended are an AODA assessment and follow through and absolute sobriety.
Basis for the public interest, Mr. Schmidt.
Judge, with the conviction that's resulting today, there's public accountability for what happened here. These were both individuals who were not known by law enforcement to be selling. They were not names that were coming up as they were dealing with people in the community or informants or anything like that. The manufacturer count is the most serious count. I don't think prison or jail is necessary on this offense for those reasons. When you looked at the setup they had in the basement, it's reminiscent of what I'd say some people make like microbreweries, like that kind of analog to it. The limited evidence we had for sale was the daughter said she saw mom exchange some for money one time in the parking lot, and they had a notebook that had some names on it. It was somewhat ambiguous. And even if you did take that to be some sort of drug ledger, there are only like 4 unique names on it. So it's not like it was probably just giving to friends is what I would estimate.
Right, how much are we talking?
What do you mean?
Quantity. In the basement, how big is this grow?
It wasn't very big. It's hard to talk about THC because the gram terminology is very different than when we talk about methamphetamine or fentanyl. The count that we charged with the possession with intent was 1,000 to 2,500, which, you know, if that were meth, that'd be a crazy amount. For THC, it's really not.
And so if I'm recalling correctly, there was, I believe, under 25 plants.
Well under, yes.
Well under, okay. All right.
Yeah, I think we found total 13.
13, okay, so that is well under. So, Ms. Stewart, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
I do, Your Honor.
Did your attorney go over this document with you?
Yes.
Did she thoroughly go over it with you, essentially reading it to you word for word?
Yes, she did, Your Honor.
And you understood everything completely?
Yes,
Is that your signature on the second page?
it is, Your Honor.
It indicates you are pleading guilty to count 2, manufacturing and delivering THC greater than 200 but less than 1,000 grams. And Ms. Campion, is this as a party to a crime or does it matter? It was charged as party to a crime.
I mean, I suppose then she's pleading to the count as charged. So
Count
yes.
as charged. Okay.
Before we dive in, just a quick note. This commentary is created for educational purposes to help viewers better understand courtroom procedures. If you prefer the raw court footage, feel free to skip ahead. Otherwise, stay with us because this case is about to reveal how a first-time felony defendant can still face life-changing consequences. Even with a plea agreement, the judge's decision is never guaranteed.
So you are 35 years old and you have 12 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, or medications in the last 24 hours, and no mental illnesses or disorders. Is that correct?
Correct, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes,
Did your attorney go over with you the maximum possible penalties you face?
she did, Your Honor.
You are charged with crimes, and each of these crimes is listed on the first page of this plea questionnaire. From all accounts, you don't have a criminal history, correct?
Correct.
So this is your first experience in a criminal court, correct?
Yes.
Did Ms. Campion thoroughly go over your constitutional rights with you?
Yes, Your Honor.
Because this is your first experience, I want to make sure that you fully understand them. Do you need me to go over those with you in any more detail?
No, Your Honor.
So you understand them completely, and do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that pleading to a felony, as such, you will no longer be able to use or possess a firearm for life?
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, Your Honor.
Do you understand what that means?
Yes, Your Honor.
Okay, so I don't need to go over that with you in any more detail.
No.
Now here, do you understand the state would have to prove as to count 2, which would be manufacturing THC tetrahydrocannabinols greater than 200 but less than 1,000 grams as a party to a crime, that on or around May 26, 2025 in Burnett County, Wisconsin, as a party to a crime, you manufactured a controlled substance, to wit, tetrahydrocannabinols, or THC, marijuana, in an amount of more than 200 grams, but not more than 1,000 grams, or more than 4 plants containing the THC, but not more than 20 plants containing the THC. That's a lot there. Do you understand all that I have just stated of what the state would have to prove?
Yes, Your Honor.
Do you understand what it means to be a party to a crime?
Yes, Your Honor.
Well, it means you either directly committed the crime yourself, you aided and abetted someone who was committing the crime, or you conspired with one or more people to commit a crime and one or more affirmative steps were taken towards the commission of the crime. So do you understand what it means to be a party to a crime?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of not more than 6 years or both?
Yes, Your Honor.
Do you also understand that there is an agreement that's been reached, and it was stated on the record, plead to count 2, that felony, have the other counts dismissed and read in for purposes of sentencing, and a recommendation of probation with a withheld sentence? Do you understand that offer and the agreement that you've reached?
Yes, Your Honor.
Do you understand that I'm not bound to follow that offer?
Yes.
And that means that I could, in my discretion, after looking at the facts of the case and hearing arguments, sentence you to the maximum possible penalty if I think it is warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? And in particular, if you look at that document, there's a section, it's called the probable cause section, where it basically says what happened that day and why you were charged with the crime.
Yes,
It
Your
looks,
Honor.
yeah, and it looks like your attorney is showing you the electronic version right now.
Yep.
For the most part, as it relates to count 2 that you are pleading guilty to, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to this charge because you are guilty?
Yes, Your Honor.
Did you maintain or did you manufacture at least THC greater than 200 but less than 1,000 grams?
Yes, Your Honor.
Ms. Campion, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
Yes.
Has anyone made any threats or promises to you, Ms. Stewart, for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you are telling the court that you fully understand what you're doing
Yes.
and voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes, she has.
Has she looked at this matter thoroughly?
Yes, Your Honor.
Has she discussed with you the discovery and evidence that exists in this case?
Yes, Your Honor.
Has she discussed with you any potential defenses or a lack of defenses in this case?
Yes, Your Honor.
Did she discuss with you what it would mean if you were to go to trial?
Yes.
Did she tell you it is your decision and your decision only?
Yes, Your Honor.
Are you satisfied with her services?
Yes.
Any questions for this court or for your attorney before I proceed?
No.
As to count 2, manufacturing or delivering THC greater than 200 but less than 1,000 grams, a class H felony, as a party to a crime, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. The remaining charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I already alluded to much of my argument in the statement on the public interest. The reason why the state really wanted to stick to the manufacturer count is mainly for 2 reasons. One, the manufacturer count actually doesn't care if it's intended for ultimate distribution. That is, if you're growing for yourself or creating a substance for yourself, it still violates the statute. It has ever since the legislature removed the exclusion for growing for personal use in 1993. So I think this is a statement everyone can agree happened. There's definitely this grow operation in the basement. There is some circumstantial evidence, as I outlined in the statement on the public interest, that perhaps some sale happened at some point, maybe in Burnett County. But to the extent of that, would be largely speculation on my part. The main driving force for why we still sought the conviction on this, even with those factors, and the fact that, quite frankly, you can just buy the substance legally if you drive 40 miles west, or you could buy something 20 miles east that is very similar to this with a similar effect legally, is because this case, as I said, did not come to our attention through the normal police channels. A child was at school who smelled of marijuana. The fact that a child is in this home and could be exposed to that is more concern. THC, the effects on adults are very different than the THC, the effects on young children. It can have longer term consequences. So we really want to minimize that. That is the main driving force for why we are seeking this disposition on this case. And we'd ask the court to follow the same. Thank you.
All right, thank you. Ms. Campion.
Thank you, Your Honor. I echo the state's request for the court to follow the joint recommendation in this matter. I think it's been alluded to already. Ms. Stewart has no prior criminal history. And I think that that is a good basis to accept the plea just on its face, and that, I think she's had a history in her life of being law abiding. She and her husband live on a home that I would describe as like a somewhat urban rural homestead. They produce a lot of their own food. They have bees, they grow herbs, they have a garden. They run a variety of businesses out of their home, including upholstery. I think they were renovating at the time of this incident a trailer to run a business out of the trailer. They both have multiple jobs, multiple income streams, and they do have people occasionally coming into their home to buy products. But I say that to kind of describe them as kind of like, like a Renaissance couple. They like to do a lot of things for themselves. Unfortunately, in this case, that also includes growing marijuana. And that's what Miss Stewart has admitted to today and is pleading guilty to today. The court was correct in the number of plants that were found in the home. I would describe it as a limited amount. Law enforcement also took some product that was frozen out of a deep freezer in the garage. Some of it tested positive for marijuana. Other product that initially was believed to be marijuana was actually mint. Like I said, they grow a lot of product in bulk. The state is correct that the case came to them not because these two were on their radar for dealing drugs in this community, but because law enforcement came to find out that a student at the high school smelled of marijuana. After the investigation began, CPS was contacted, which makes perfect sense. And after an investigation, it was determined that she was safe to remain in the home. I don't think there was ever concern presented that this individual, that their daughter used marijuana. So I do think that that is an important factor in considering what the outcome is here today. So when we think about the gravity of the offense, I do think it is limited to this couple, this family. I understand the state's description of the circumstantial evidence in this case. I as I alluded to previously, they have several businesses that they run out of the house. I think the ledger that was found related to the upholstery business, not the sale of marijuana. The instance of the potential alleged sale that was described by the daughter, I don't think that she saw marijuana exchanged. I don't think that was the description that was made. So certainly, I think there's very, very limited evidence, if any at all, that this left the home. So really, it was in the home, and it was limited to Mr. and Miss Stewart, not their daughter. So it's product being used internally. That said, there is still obviously a concern for the protection of the public and certainly a protection for their daughter. I think that that's addressed, in line with the rehabilitative needs here, which is to say that they don't grow that product anymore. Their daughter is a freshman in high school. She'll be in the home for at least another 3 years. Obviously it's not legal to own and possess in Wisconsin. So indefinitely that's the solution, but certainly something that the court would want to take into consideration while their daughter is still in the home. I think that this agreement allows for that supervision for that time, which I believe is appropriate here. Additional rehabilitative needs outside of just not having that product. I think certainly an AODA assessment is useful to ensure that any treatment needs are addressed. I don't believe there are any additional needs. Ms. Stewart works. She's a mother. She's provides for her family. I don't think that either party has identified additional needs. I think that taking accountability today, having the felony on her record is certainly extraordinarily serious. Having no criminal history prior, it will impact her for the rest of her life. That alone, I think, is a significant punishment here. And so I think that that is sufficient and does not require the need for jail. Certainly it's available if she violates probation, but I think that giving her the benefit of probation to begin with is appropriate here. 18 months, in my mind, is a sufficient amount of time to address the seriousness of the offense without, dragging it out for an unnecessary period of time that ultimately could just waste taxpayer dollars that we don't need to do, but allows for an extended amount of supervision to ensure, that Ms. Stewart remains law-abiding moving forward.
Thank you, Ms. Campion. Ms. Stewart, I'm now going to give you an opportunity if you wish to. You don't have to, but if you wish to make any statement, let me know anything that you want me to know. If you've heard something you want to correct, or if you've heard something you want to expand upon, you will have the floor if you wish. Again, you do not have to.
No, thank you, Your Honor.
Okay, thank you.
Now comes the most important part of the hearing. The guilty plea is already accepted, but sentencing is where the judge weighs accountability, public safety, and the defendant's background. Do you think probation is the right outcome here, or should a felony drug case always result in jail? Let us know your thoughts.
Ms. Stewart, in sentencing an individual, a court has to do certain things. First, I have to look at the nature and the gravity of the offense. How serious is this matter, okay? Then I have to look at you and your character, any past criminal record, your age, your education, a whole bunch of things about you. If you have any specific needs, mental health, AODA, those types of things. And then thirdly, I have to look at needing to protect the public. Here, we're dealing with a substance, an illegal substance, THC. And as Mr. Schmidt argued, you can go in any direction pretty much out of the state of Wisconsin, and you can get THC legally. Not here, not ever, and I don't see it in the near future, but I'm not the legislature, okay? They get to decide. The issue with this case is because the issue is the growing, having that grow operation of the THC. There's not concrete information that it rises to a higher or more serious level, because there may be some sales, but there's no way to determine whether or not that's accurate or true, or what that even meant. And with the small amount of plants, this isn't a tremendous grow operation. It's not under a huge, the whole basement. We don't have we've had grow operations in this county before, acres. Okay, this is not an acreage issue. This is 13 plants or they're around. I don't know why or the reasons that you have or your husband has or anything about why you smoke THC. Again, it's illegal in Wisconsin, any way, shape, or form. Own, possess, sell, whatever. But I'll leave those things to you and to a probation agent to determine. The other area here that raises the seriousness is the fact that it involved your daughter. And that's what I look at the most here, is because a juvenile who now is a freshman in high school, but was 8th grade at the time of this incident, it put her in a very difficult position. I don't know you. I don't know your husband. I'm going to guess that it's your daughter together, but I don't know that either. But it's putting her in an extremely awkward position. Because you're her parents. She loves you. She respects you. She wants to protect you, even though you're to protect her. But then she goes to school and it's inevitable that it's found. And I'm sure there's a lot going on internally with her. Hopefully that's going to be addressed, and hopefully she knows that her mama and her daddy are not upset with her, that she did the right thing. Because again, she was put in that position. She doesn't need to carry the burden that the adults have. She needs to be a kid and experience still being a kid, because a freshman in high school is still a kid, still a very young girl who has her whole life in front of her. And we don't want to make it any more difficult than it already is. High school sucks. And I'm sure it's even worse now with all of this technology. So this it edges towards seriousness. And I do have to look at the protecting of the public. I have to look at, now, is this something that I have to deter others from doing? Do I have to look at, am I going to be needing to deter you from doing this again or doing something similar or any other crime? You are an adult woman of an age where you do not have a criminal history of any kind. And I'm going to tell you, you can probably sneeze in one of these counties and get a disorderly conduct, okay? So the fact that you don't have any type of criminal matters in your background says a lot about you. And hopefully that this is going to be the time that you're going to make the change and you're going to do the things. And you're just going to make sure that, you know, sometimes parents don't always do the right thing. We don't. But hopefully you're going to be better at not showing your daughter those types of things. I think probation is appropriate. 18 months of probation is not going to be fun at all. You're going to have to check in with an agent. You're going to have to do some drug testing and all those types of things. And hopefully it's not going to get any further. 18 months of probation, I will follow that recommendation. I'm even going to follow the recommendation for a withheld sentence. Now, I never think, I'm going to tell you right now, and I'm going to say it on the record, this is never going to be a prison sentence unless, let's say that maybe you were found again with a grow operation and then it's bigger and all those things and you don't learn your lesson. But looking at the facts here, this is not a prison case. The fact that you are now a convicted felon, where this is going to remain on your record forever, that's a punishment. That's a punishment alone. And to have the probation and all of those requirements that you're going to have to do and you're going to have to complete, that's a punishment. And I think having those punishments and penalties on you, I think they are going to hit you hard, and I think they are hitting you hard. You're just better at putting on a brave face and being strong. I don't foresee revocation in this matter, so I don't believe I will need to make any determination upon any type of incarceration sentence. And that's why I'm not doing an imposed and stayed, because I can't say with this case how much jail, at least at this time, it could be. I don't think I'm gonna have to worry about that. I think you're gonna do all that you need to do to stay on the straight and narrow. I am going to assess $500 in fines and fees and court costs and surcharges. I'm waiving $18. I'm not going to make you come up with the other 18. You already have $500 posted. Conditions of probation, absolute sobriety. That means no alcohol. That means no illegal substances. Regular testing of both alcohol and or illegal substances. I don't necessarily know or believe that you may need an AODA assessment, but it's not, it won't harm anything to go through that and to do that. So I will order the AODA assessment. I don't see many other conditions here. Just stay out of trouble so you're not going to be back in front of the court. And you are working?
Yes.
Where do you work?
I own my own cleaning business and I also work at the Pheasant Inn in
Okay.
town.
All right, so I'm not going to put on a no bar, no establishment that serves alcohol. I don't think alcohol is your issue, honestly. I'm not saying that you have a issue, or I'm not defining you as having an issue, but with this case, there was an issue that needs to be corrected. I do need your DNA. You're going to need to provide that to the jail. You'll come up here and get a form when we're done. Go to the jail, provide your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice, not to me, to the Department of Justice. It's really easy to do. You can Google it or ask Ms. Campion. I'm sure she can explain it to you. This, I believe, would be able to be expunged. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Again, felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. Mr. Schmidt, what am I missing?
Nothing from me.
Did you stay overnight, Jim? Did you get up next?
2 days
Or
of jail
arrested?
credit. She was, yep. So I believe 2 days of credit.
Okay, 2 days of jail credit if you are revoked. Oh, I bet that was a lesson in and of itself as well. Even
Yes,
though we
Your
have a
Honor.
beautiful new jail. I hear it's, well, I've seen it. It's beautiful. 2 days of jail credit. Anything else I'm missing, Ms. Campion?
I don't believe so, no. Does she need to report today?
For the DNA, yes.
No, I apologize. For probation.
Oh, for probation. Yes, that too. And you're still in Lynchbridge Road,
Yes.
2314, last four of your cell? 23.
Oh, that's
14?
his. Mine is 0301.
Oh, sorry, I pulled up his.
Oh,
Yours is 0301. Got it. All right. So report to probation as soon as you're done providing your DNA. Just go over there. They'll get everything started and they'll get you going. Okay.
okay.
So come get the documents from the clerk and then you are on your way.
This case shows how a first-time offender can avoid jail yet still receive a life-changing felony conviction, probation, fines, and strict conditions. The judge emphasized accountability while recognizing the limited scale of the operation and the defendant's lack of criminal history. If you found this courtroom breakdown informative, be sure to like this video, share your opinion in the comments, and subscribe for more real courtroom analysis and legal case breakdowns.
Thank you, Your Honor.
Mr. Stewart. On the record in the matter 24 CF 336, State of Wisconsin versus Andrea Andrick. The state appears through District Attorney Kevin Schmidt in person. Ms. Andrick appears in person with counsel Daniel Chapman. We're set today in this matter for a status conference. Mr. Chapman, please update the court.
Your Honor, the matter is not resolved. We need a jury trial, please.
All right, how many days, Mr.
Probably,
Schmidt? Mr. Chapman, you too.
I would say probably one,
That's what I
almost
was
certainly one.
gonna guess, but Mr. Schmidt, do you think more than one?
No.
And you're pretty confident jury?
Yes, Your Honor.
Mr. Schmidt, I could look at the 14th or the 15th of July. It says only one DA. That's you, but do we need Mr. Vila here at all?
No, I can do those.
Either of those days work for you, Mr. Chapman? Or we can push it to
Either of those
September.
days work for me.
Or would you prefer September?
July is good.
All right, so then let's do July 14. One day. Final pretrial. June 18. Are you available in the morning, Mr. Chapman?
I am.
All right, so you have your pick of times. What time in the morning would you like to be here?
Let's say 10 o'clock, Judge.
10 o'clock, June 18th. June 18th at 10 o'clock. All right, thank you. We will see you then. You can come get your notice, and then Mr. Chapman has a whole bunch of other cases right now, okay?
Do not leave. I will talk to you when I'm done with all my other stuff.
I believe I have Sherry Koppa on the
Kappa, yes.
video. We will go on the record in the matter 25 CM 90, State of Wisconsin versus Sherry Koppa. The state appears through District Attorney Kevin Schmidt in person. Ms. Koppa appears by video conferencing. Her counsel, Daniel Chapman, is in person. We're set for a status conference. Mr. Chapman, please update the court.
Your Honor, Ms. Kappa is actively participating in the intoxicated driver intervention program. I know there has been some difficulty with her assessment becoming completed because the person she was referred to, I believe, canceled her appointment and doesn't do them anymore. She has been in communication with Tessa. I believe she's done with her community service. So I'm just asking for another status to give her time to complete that.
Well, you're June 18 at 10. Think that's enough time?
I would hope so, Your Honor.
Right, June 18th at 10. If by chance everything gets worked out and she would like to have a resolution before then, just call Mary.
I will. Thank you.
Thank you. We're adjourned. Thank you, Ms. Kappa.
Thank you.
Kappa. All
Kappa.
right. Thank you, Mr. Tyrone Hoff. We will go on the record in the matter 26 CF 29, State of Wisconsin versus Tyrone Hoffbeck. The state appears through District Attorney Kevin Schmidt in person. Mr. Hoffbeck appears in person with newly appointed counsel Daniel Chapman. We're set today for an initial appearance. Mr. Chapman, were you able to go over the criminal complaint with Mr. Hoffbeck?
I was, Your Honor.
He understands charges and maximum penalties,
He does.
formal reading or waive,
We will waive reading of the complaint.
enter not guilty pleas on
Yep.
the misdemeanors.
On the misdemeanors, yes.
Are you still on Plover Street?
Yes,
Telephone ends in 0494.
yes,
May we send you text message notifications of upcoming hearing dates?
yes.
Thank you. Prelim within time limits.
We would ask for a preliminary hearing, but we're not standing on the time limits.
I can do May 28th at 11:15.
I have a trial that day, Your Honor.
May 6th at 10.
That works just fine.
All right, May 6th at 10, we'll have a preliminary hearing. Come up and get your notice and you're free to go. Thank you.
If you have any other questions for me, we didn't have a lot of time to talk, hang out in the hallway and I'll be out there. Actually, wait around because I need a phone number for you too. Okay. Thank you.
Ms. Matrius? Alana?
Would you, Mr. Schmidt, would you like to approach and tell the judge any details about Ms. Matrius? We're just asking for a status.
You want to go, do we need to go in chambers? Or
I would
can
say yes, Your
Can
Honor.
I just pick up what you're putting down?
I would say let's go in chambers.
All right, okay.